Donna Adelson wants her murder trial moved to a smaller courtroom, and she's not even shy about saying why. She doesn't want you there. You, Jane Q. Public, John Q. Public. She wants as few members of the public as possible in the courtroom. And she's saying that. She's not even hiding it. That's what she tells the court. What she is asking for would limit public access, would cut down on the media's ability to report on the trial, and would set a precedent that would hurt the rights of other defendants. We're going to talk about that. Hi, y'all. Welcome to the midday extra bonus stream. We will have our normal live at 7 p.m. Eastern, but this is a bonus episode because I wanted to dive into Donna Adelson's motions. Today, I want to talk about the one where she asks the court for a smaller courtroom. And I'm going to talk about why I think the court should not give her a smaller courtroom. Now, Donna Adelson has been charged with first degree murder, conspiracy to murder, and also solicitation to murder her ex son in law, Dan Markel, a law professor in Florida. Her son has already been convicted of hiring two hitmen and his now former girlfriend to kill Dan Markel. And in just a few weeks, Donna Adelson will be arguing to Tallahassee jury that she had nothing to do with the murder and that she had no involvement in the plot to kill her ex son in law. The son in law, Dan Markel, was locked in a very bitter custody battle with Wendi Adelson, Donna's daughter. So let's take a look at the motion that she filed. Mrs. Adelson's upcoming trial is scheduled to proceed not in this court's regularly assigned courtroom, but in courtroom 3G, which, as the larger of the two, can accommodate more members of the public in its gallery. So presently, the trial is set for a particular courtroom, which, being larger, could have more people, but Donna Adelson would prefer to have it in the smaller courtroom. Let's read on. The decision to use courtroom 3G was, we imagine, a response to the public's demonstrated interest in this case and in keeping with the Florida Supreme Court's position that the public should generally have unrestricted access to all judicial proceedings. So she acknowledges there's a reason for this. This is not simply the court selecting a courtroom. This is the court trying to comply with the Florida rules that say he has to allow the public access. That's a Supreme Court ruling he's trying to follow. As the Supreme Court has made clear, however, the public's right to access is not absolute, but must yield in order to protect a defendant in a criminal prosecution from inherently prejudicial influences which threaten the fairness of his trial and the abrogation of his constitutional rights. Where a defendant's right to a fair trial conflicts with the public's right of access, it is the right of access which must yield. Unfortunately, as we learned during Charles Adelson's trial, Charlie is Donna's son, in highly publicized cases like this one, the more observers there are in the gallery on any given day, the greater the risk to a defendant's constitutional rights. Now, Florida's rule that there should be public access, that's not just a local rule in Florida. That is related to a constitutional right that Americans have. We're going to be talking about that in just a minute. But she actually says here that in highly publicized trials, members of the public are a threat to her constitutional rights. That turns the Sixth Amendment on its head. It's the opposite of what the Sixth Amendment said. According to Donna Adelson, members of the public are the big risk to her new trial, but in getting a fair trial. But the Sixth Amendment says your right to a public trial is what protects your right to a fair trial. So let me go ahead and add the Sixth Amendment to the stage. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. The accused. That means the right belongs to the defendant, to the person being accused of the murder. It's that important that there be a public trial. That's in order to protect the defendant from a star chamber kind of place where they are convicted behind closed doors with unknown evidence and the public has no oversight. This is a protection that defendants have in the United States, and she's wanting to take that away to remove that protection of public oversight. Now, she's going to give a few examples of problems that she thinks might arise and says did arise in Charlie Adelson's case. She says there would be fewer of these problems with fewer people in the courtroom. In Mr. Adelson's case, for example, someone in the gallery took a photograph of a note passed between Mr. Adelson and his counsel on the second day of jury selection and proceeded to post that note on social media. While the substance of the note was unrelated to Mr. Adelson's case, the reporting in the media speculated about the note and its importance. Moreover, the fact that it was photographed and released for public consumption forced defense counsel to modify how and when they communicated with Mr. Adelson for the duration of his trial. I have not been able to find this specific photograph that she's talking about or the speculation that she says occurred on social media. I don't really doubt that it happened. I just can't comment specifically on it because I wasn't able to find it online. But the remedy for this sort of problem is excluding the person who created the problem, not excluding the public. The remedy is addressing the problem that actually occurred, not one that could occur. So you would, for example, exclude that person. You would take away cell phones. You would not exclude every member of the public or large numbers of the public because one person took a picture they should not have. Let's keep going with her examples of what she says occurred. Even more significantly, later on in the proceedings, during the cross-examination of an important government witness, one of the jurors stood up in the middle of the examination and signaled to the court to stop the proceedings. After the court spoke with the juror, we came to learn that individuals in the gallery were making facial and hand gestures toward the jury in an effort to convey opinions of the testimony, which were distracting at least the one juror who complained of the incident. Actions like this may clearly affect the juror's ability to independently assess the testimony and thereby affect a defendant's right to a fair and impartial trial. And may I say, good for the juror for standing up and saying something. Absolutely, this is not appropriate. It's not allowed. But here, the judge put a stop to it. There was one example, and it was handled correctly, which is the judge said, no more. This is not happening again. That's exactly the way it ought to happen. We'll keep reading. And at several points, the proceedings were interrupted when members of the public, contrary to this court's clear admonition, attempted surreptitiously to record the proceedings and failed to silence their cell phones. Well, obviously, cell phones need to be turned off, but the judge was telling them that. For all three of these problems, there is an easy remedy: the judge. This is how you handle that problem. We saw it done in another case, the Traconis case, where there were facial gestures and so forth coming from members of the public sitting in the gallery. They were actually family members of the defendant or of the deceased. And in this case, we saw the judge handle the problem. Here's how he did it.
What the court is not going to countenance are competing pep rallies like you have in high school. The defendant supporters and the state supporters. This is not high school. The court is not going to become a hallway monitor. So if there are efforts to communicate with a jury or a witness, you will be removed. No hearing, just removed. There will be no computer use other than by counsel in the courtroom. There will be no communication with the gallery at any time. There will be no attempts to show your approval or disapproval of a witness's testimony, or you will be removed.
So the judge goes postal on everybody and it stops. That's how it works. The judge deals with it. That is exactly the judge's job. The solution is not to change the rules that protect most defendants by excluding or limiting the access of the public. That would be a last resort. not a first resort, or in this case, something to be done even before a problem arises. In a case with tremendous attention and strong opinions that is covered virtually every single day in all sorts of social media and other media outlets, there is a risk of a larger live audience creating a sort of mob mentality in regard to reactions to testimony. By limiting the size of the audience, this court limits the probability of emotional outbursts and reactions in the gallery. Simply put, a larger gallery audience elicits larger responses to the testimony and thereby a larger chance of influencing the jury. Now, this is, in fact, the opposite of what the Sixth Amendment stands for. The amendment stands for the idea that public access would ensure that there was oversight of the government, because it would be dangerous to have government officials gather in a secret room and make all the decisions without the oversight people who were not part of that government. The fact that after seeing the evidence, the public comes to believe that the defendant committed a crime, that's not prejudice. That's simply their beliefs based on actually having seen and heard the evidence. The prejudice happens if you're convicted and the public is never allowed to see the evidence. It's never allowed to weigh whether or not you have been treated fairly. We saw that dynamic in the Karen Reed case, where many people looked at the evidence, they concluded she was not guilty and that she was being prosecuted unfairly. The motion goes on. All of these types of incidents described above, should they occur during Ms. Adelson's trial, and note that they haven't yet, will threaten her ability to secure a fair trial and risk a mistrial, which no one wants. While Your Honor certainly does his best, the easiest way to mitigate these risks is to reduce the number of in-person courtroom observers, which this court can readily achieve by ordering that trial be held in courtroom 3B. The touchstone, though, isn't what's easier. Yes, it would be easier to exclude the public, to have judges convict everybody, to not worry about pesky things like rights or the public. But it's also very dangerous to justice for that to happen. The solution is that the judge do just what the judge did in Charlie Adelson's case, what the court did in the Troconis case, which is if one individual acts up, you remove that one person. You tell people this can't continue. I'm not going to permit it, and you don't. By the way, I will say I don't recall emotional outbursts and reactions being a significant and ongoing problem in Charlie Adelson's case. I was watching it on camera, as many of you were, but I don't remember that being a significant ongoing problem. If something arose, the judge handled it, just like in the Troconis case. That is how it is supposed to work. The courtroom will still have a live camera feed, so for anyone unable to attend in person, if passed as prologue, Mrs. Adelson's trial will be televised live on a national network. And as you are aware, many of your trials are routinely held in courtroom 3B, and none of those cases violate the Florida Sunshine Laws of the public's right to access. Donna Adelson is arguing here that the public will still be able to attend by watching on TV. To some extent, that's true. And she says that the smaller courtroom, that's constitutionally acceptable in other cases. Why isn't it good enough in her case? But she's missing the point, which is that fewer people want to attend the other trials. The courtroom isn't as crowded. People who wish to see the trial aren't being turned away. They're getting in. So the court is just trying to make it possible for the public to attend, as is the law. If the court limits the attendance here when it does not have to, when it has a courtroom that's big enough to accommodate everyone, that is a slippery slope. Is it always unfair to have 150 people watch a case? What about 100? Would it be unfair to have 50? Is 25 still unfair in some cases? Or why let in the public at all? Just ignore the Sixth Amendment. Shouldn't we just trust that everything we see on the television feed is correct? Or maybe even don't have the television feed? There is one other argument that they make that's a little bit different. On a separate note, courtroom 3G, as it is currently configured, Also creates logistical issues for defense counsel that do not exist in courtroom 3B. Among other things, it is virtually impossible for a defendant or her counsel to see all of the jurors while seated at counsel table. Further, the lectern's placement immediately to the right of the state makes it difficult for the defense counsel to use the Elmo or other electronic devices during examinations, and makes it difficult for counsel to see all the jurors while the examination is occurring. Moreover, the gallery is in direct view of the jurors while examinations are occurring, which can cause attempted influences from the public, which should not be allowed in the trial. All of these concerns are not as prevalent in courtroom 3B. So this is a different argument, but these all sound like logistical problems that can be fixed, moving the lectern, turning the table a different direction. If they cannot be fixed, that would be an independent reason for changing courtrooms. But we get this in the next to last paragraph of her entire motion. They've already stated, Donna Adelson's team has, that the real reason is to exclude the public. They don't hide that. And actually, I admire them for being honest about that. I respect them for going ahead and stating the actual issue as they see it. And if the court moves the trial because of these other technical, logistical factors, then that means the court is going to have to move every trial, or at least every time anybody asks about it. Essentially, this courtroom will not be able to be used. In summary, Donna Adelson believes that she would be better off without a public trial. Now, she may be right, but this is not about Donna Adelson. This is about a fundamental protection for defendants, which is the public right to oversee what happens in courtrooms across our country. We are weighing two sets of benefits: the benefit to Donna Adelson of locking out the public, and the benefit to defendants in general of allowing public oversight of the legal system. Now, what's the benefit to Donna Adelson? That fewer people might break the courtroom rules. That's fairly weak. That fewer cell phones might ring in the courtroom even after the deputy has asked people to turn them off. That's very weak. The real reason, and she's upfront about it, is she believes there will be fewer public comments and informed media reports. That might be good for Donna Adelson if they are all negative about her. But if fewer comments and informed media reports, is that really a good thing? I would say no. I would say, in fact, it's just the opposite. Looking at the other side, the benefit of allowing the public to attend, of letting the media be present so that they can report based on what actually happens at trial, that's a very high benefit or good. She's right that there is an alternative since the case is televised. But public oversight takes many forms, and in person is definitely and has always been one of them. Weighing these, it's not even close, in my opinion. Intentionally moving the courtroom for the express reason of excluding members of the public who want to attend, that is setting a precedent that we want to limit public attendance at trial, that we want to tamp down on public oversight of our legal system. That's not a public good. And it spills over to other defendants and hurts their right to a public trial. The Sixth Amendment is designed to prevent a star chamber where the government accuses you, you go into a black hole of a trial, and then on the other side, the government just informs everybody, yep, like we said, just guilty, guilty, guilty. And no one understands why, or even whether it was true. Judge T.S. Ellis III said, a public trial requires witnesses' testimony to be public, so it deters perjury. It requires a judge's rulings to be made in public, as today, so it deters partiality and bias. And by requiring prosecutors to present their charges and evidence publicly, it deters vindictiveness and abuse of power. So we're weighing the chance of small disruptions in the courtroom and more comments by the public and media against keeping witnesses honest, avoiding partiality and bias, and preventing judges and other authorities from abusing their power and using our legal system to exact revenge on people. That's a no-brainer. The fact that the trial is public is what guarantees the fair trial, not what prevents it. Like and subscribe for more content on the legal cases everyone's talking about.